Aloha mai kako. My name is Jocelyn Costa. I live on the island of Maui, and I belong to a think tank, I call us, Hui Pono Ike Kanawai, that disseminates information that we've discovered throughout the years and share our own firsthand um, um, events as we traverse the idea of uh, Hawaii, its history, our identity, and our rights. So today's talk is on defined or defiant. We will live in declaration, not in darkness. And I have a picture here of my daughter and I when we participated in this thing called a kaapuni. We walked around the island of Maui in 2008, I believe, during Makahiki. And it was significant because at the time of old, the ali'i would walk around the island to assess the health of not only the island itself but its people, and find out if there's pilikia, if there's good things happening, if they need to address certain things within the area. And so we went, and it was a good experience. We carried a map with us so that when the kupuna would give us their stories, we would throw the identities of the places there, and we were able to listen to them give us their stories as well. And just by our ears to hear them and to allow them to speak was healing for them and gave them energy to carry on. So where did my journey begin with these discoveries? So define. Define, as I found it in the dictionary for Webster, is to determine or identify the essential qualities or meaning of, to discover and set forth the meaning of. It also is to affix or mark the limits of demarcate, to make this distinct, clear, or detailed, especially in outline. And if you see my watermark, I'll come to this document during my presentation. Defiant, full of or showing a disposition to the challenges, resist or fight, proudly refusing to obey authority. So I bring you to my halepule. Well, it's actually back in the day they would call the churches not halepule but luakini, a place of worship. This particular building, it was located in Hamakualoa in Haiku, Maui. The church is called Kalanikahuaho Congregational Church. This particular luakini, we found out, was very defiant when the provisional government, Territory of Hawaii, said it's illegal to celebrate Lahakuoko'a, our independence. They continued. The families would celebrate that day every year. So, what did we do? Because our history gets kind of gleaned over, and then we tend to forget. We have these holidays, but where did it go? So we found out our luakini celebrated it. So we celebrated it, put out a big banner, rented out the hall right next to our halepule, and we said we are going to celebrate Lakuakoa in our luakini, and then we'll have a celebration at the hall so we can accommodate everybody. And the leaders all said, who are we going to be celebrating with? Because that particular year, in 2019, Lakuakoa, which is November 28th, landed on the same day of Plymouth Rock, the fake celebration of supposedly Thanksgiving, where the settlers and the Indians all got together and had a beautiful feast. But we said, no, that's the day that Lakuakoa is, November 28th. So there was a lot of groups on Maui that said, we're going to celebrate too. Why don't we just push it back and we'll just come together as one big celebration on the weekend because people will, be more apt to come. And we said, well, because that's not the day. So we were very steadfast and defiant on the day because it was defined to us that that is the day of independence. And so we did. And this is what happened. They came. We filled up that hall. Out on the grounds, we had makahiki games going on for the children. And we flew in Dr. Ron Williams to speak about Lakuakoa. We also had our own um, speaker, Kalekua Kaeo, to speak on the day as well. We had a huge buffet for everyone to eat. Everything was done for free. And we had a makeke table where our members brought from their yard all the gatherings of fruits and vegetables and whatever else they had. Maybe would have pula pula, cut tea leaves, baby uh, banana tree maya, and ulu. Whatever we had, we put on the table, and you could bring your eke and fill it up and take it home for free. So what did it do for me personally? It questioned me. Am I American or am I Kanaka Maoli? Now, I was already in the mode of, trying to discover this and figure out if I was, if I wasn't, how I'm not, or how I am. And Connie does a really good presentation on identity. But I did know that there is something to do with our kupuna. So I started here on the KUE petition, because that then defines the line of whether we crossed over to be with the provisional government or if we stayed with our kingdom. And in this picture is my kupuna and the page of the KUE petition where our kupuna signed. This is all a kani, starting from Kuhelepo all the way down to this 2-year-old. So what did it further make me do? I did my genealogy. So on this particular slide, I am showing you 7 generations of Kauiho. So we start out with Kuhelepo. Kuhelepo had a son, Aka. It looks like an R, but that's Aka. His name was Arthur Kauiho. Arthur Kauiho, which is here, his picture, had a daughter named Mary, Mariah. That's my tutu lady. She had a son named James. It's my dad. He had 3 children. That's me. I had 3 girls, 1, 2, 3. And my daughter had children, my mo'opunas here. So we have 1, 2, 3, 4, 5, 6, and 7. 7 generations. And not one of us has ever taken any type of oath of office to the United States. So it's not something that they can take away from us. We are still within the kingdom and we are still subjects of the kingdom of Hawaii. So now that we know of our identity, we then question, okay, so the land that Tutu was talking about, what does that mean to us? And in my studies, in my discoveries, I found the Hawaii Revised Statute, which is 172-11. But moreover than this is the beginnings. Where did this law originate from? And it says here, the law of 1872, chapter 21, section 1. And here is the law of 1872, chapter 21, section 1. And it reads, every royal patent hereafter issued upon the award of the Board of Commissioners to quiet land titles shall be in the name of the person to whom the original award was made, even though such person be dead, be deceased, or the title to the real estate thereby granted have been alienated, and all royal patents so issued shall inure to the benefit of the heirs and assigns of the holder of such original award. Very powerful words. I would encourage you to take a look at these words, ponder upon it, and even find definitions for each. When we read the current law of 172-11 from the Hawaii Revised Statutes, it says, every land patent issued upon an award of the Board of Commissioners to quiet land titles shall be in the name of the person to whom the original award was made, even though the person is deceased, or the title to the real estate thereby granted has been alienated, and all land patents so issued shall inure to the benefit of the heirs and assigns of the holder of the original award. Sounds the same, right? It is pretty much word for word, except for just one word, which would change everything, why it's revised. The state of Hawaii has, the state of Hawaii is making claims on KANAWAI, is making claims on every land patent. Everything else in here is word for word. Only when it comes to the patent, they call it land patent. In our original, in our kingdom, in our country, it is royal patents. State of Hawaii, United States does not hold Hawaii Kingdom royal patents, but they hold land patents. And of what commission are they talking about? Who are these people? At what time frame does it come from? So what do? We go back to the aina. We go find the aina and we say, okay, so because we come from this aina, we go home and the first thing you want to do is malam. And this here is a section of the aina that has the heiau, and this is a fishing heiau. And over in this little area that we still have to clean is where they would park the canoes. There's a structure there that can hold 2 canoes. So across the street or dirt road from this property, there was going to try to do a subdivision to carve out a section that they weren't going to touch because it's on the historical registry. It's a well-known heiau. So I had something to say about it, but in order for you to voice yourself with any kind of weight with the state of Hawaii, they have to recognize you as having some kind of relationship within this land. So they recognize our family and our genealogy of this place. And so because of that, we were able to speak on behalf of our concerns across the dirt road. So the State Historic Preservation, through their burial council, acknowledged our family as a cultural descendant because we're speaking about across the street, across the dirt road, because they recognize that we have lineal ties to this property that's right next door. So it's important sometimes, I found it, for them to know that we still exist. Do I need them to tell me that I exist? No. But a lot of times when you have to make yourself known, these types of documents will help you open the door. So we go home. Easier said than done. Sometimes when you do go back to the aina, these things happen. Trespass, criminal trespass, not 1, not 2, not 3, but 4 counts against my father for being there. However, like I said, the area was well known by our family and its community, not just in the Ko'olau Nahiku, but further into Hana district. They knew of our family. Ke'anai knew of our family. And we were right in the middle between Ke'anai and Hana. And all of the authorities, as well as the community, knew of our ohana. And so because of that, the police department would not bring forward charges. My father was never processed, nor was a charge put against him, but they still went forward to try to make a case against him for trespass. What happened in the case? Because there was no charging document, this case was dismissed with prejudice. We belong there, and we can prove it by our identity, by our ohana, by even the state historic preservation with that piece of paper, um, that we have an interest there. Not an owner. The owner, like I said in that previous, is the original awardee. But because we are blood relative, we have a say and a interest there. So in that contemplation of this land, I had to question, then why do they keep pulling us into court, and why do they keep questioning us if we have any validity? And I started to uh, engage in an event up in Wai'ehu, which talked about the boundaries. Remember my intro with Defiant? There was a little watermark in the back, and I'll get to that, but it talked about boundaries. And I found this in the Kakului library when I asked the librarian for the Constitution. And in here was the Doctrine of Political Question. This document states it is not within the province of the courts to inquire into policies underlining actions taken by the political department, Congress, and the president in the exercise of their conceded powers. In other words, the courts, they have limitations as well. If it's a legal matter, then it's for the courts to take up. But if it's a political matter, such as one country against another, then it's for Congress and the president. Now, remember when I showed you 172-11 as opposed to the laws of 1872? Legal matter would be the Land Commission Award. Foreign matter would be the Royal Patent. So, as we go on and read, this commonplace maxim is, however, sometimes given an enlarged application so as to embrace questions as to the existence of fact and even question of law, which the court would normally regard as falling within its jurisdiction. So sometimes the courts think that they can, but such questions are termed political questions and are especially common in the field of foreign relations. So our documents are of a foreign matter because it was created of a foreign country. And it says here further, the leading case is Foster versus Nielsen, where the matter in dispute was the validity of a grant made by the Spanish government. See, not even a royal patent, it was a grant, but the Spanish government created it in 1804 of land lying in the east of the Mississippi River, and in which there was also raised the question whether the region between the Perdido and Mississippi rivers belonged to, in 1804, to Spain or to the United States. Chief Justice Marshall's opinion of the court held that the court was bound by the action of the political department, the president and Congress, in claiming the land for the United States. In other words, it wasn't up to the courts to decide. It was the president and Congress of the United States. If those departments, which are entrusted with the foreign intercourse of the nation, which assert and maintain its interest against foreign powers, have unequivocally asserted its right of dominion over a country of which it is in possession and which it's claimed under a treaty, if the legislature has acted on the construction thus asserted, it is not in its own courts that this construction is to be denied. In other words, the courts cannot make the decision, and they cannot try to redo whatever the Congress and president. It's up to the Congress and president. And we can find several documents that state Hawaii, it was never annexed. There is no treaty. Yeah, we are a foreign country, and the documents we hold is from a foreign country. So I went up to Wai'ehu and I was defiant. And when you become defiant, you come across these types of things, such as Maui Police Department, the CIU, Criminal Investigative Unit. We also had the SWAT team come up. And all we was doing was kuleana to kokua the kupuna up there with their Royal Patent Land Commission Award, because this particular entity claimed that they owned this land and they were going to put up a huge subdivision. The first house, I believe, was supposed to have been built in 2005. We're in 2024. There is not one house yet. So remember that watermark about boundaries. So what this developer was doing was trying to capture a lot of land commission awards by creating a one huge TMK and then claiming to own the entire TMK. But there's boundaries here. So let's see what Hawaii boundary law and land owner dispute has to say. Original lines remain fixed. Principle 5, no surveyor or court has the authority to alter or modify a boundary line once it is created. It can be interpreted only from the evidence of where that boundary is located. Pretty cool, yeah? Retracing surveyors will encounter a minority of surveyors who, when finding an error in the original survey, believe it is their responsibility to correct the error and make the original bearings and distance as they should be had they been surveyed correctly. These surveyors have no concept that once the lines have been created, no consequent surveyor has authority to recreate the original lines. When a creating surveyor indicates a distance or an angle, these are the original measurements according to the creating surveyor's methodology and errors. By law, they are free of error, even though, in fact, we do realize the creating surveyor made mistakes. This concept also extends to the presumption that the survey is correct. So what they're talking about was back in the day, the way they would measure was not with those laser beams or anything. They take roods and rods and chains and throw them and say, okay, now from here to here, and then throw again, and from here to here, and then they would make their measurements. And once they affixed that lines, whether it was a little bit off the way they threw it, it didn't matter. The lines are now affixed. So differences do occur because of the different methods and equipment used in obtaining the original measurements and the subsequent measurements, as well as differences among the people who did the work and changes in the circumstances or conditions under which it was done. Moving on. People, including many surveyors and attorneys, let me repeat that, people, including many surveyors and attorneys, use words freely such words as love and friend often have different meanings as used in everyday speech from their true meanings. Surveyors use the term property boundary very freely on maps, in reports, and in everyday conversation. No surveyor has the authority to identify and locate property boundaries. No surveyor has the authority to identify and locate property boundaries. And within that box there, it says without judicial authority. Now we have to go back to that other document, right? Judicial, political, so you have to also include that question. But without judicial authority, no surveyor has authority to locate property boundaries. So I have a little clip of when we went up to Wai'ehu just to prove that it really did happen. And here we go.
Over who owns a piece of land on Maui led to the arrest of 16 people over the weekend. On one side of the land dispute, Hawaiian families have claimed royal lineage to the
sorry.
in Waiahu. On the other side, the developer of the planned Halimua subdivision. The group says it went to the site yesterday for a cleanup. That's when police told them they were trespassing.
We don't feel we're trespassing because Halimua does not have jurisdiction to that property. They're saying they do, but they have to show me their deed and I'll show them our deed. Now, who has the right to them or us?
Yeah, baby.
They got all this planted. They got squash and all kinds of stuff along this hill.
The group claims to hold royal patents to the land, which they say are passed down from one generation to another and cannot be sold. Most of those who were arrested were released after posting bail. As of this morning, 6 people remained in custody.
So, just so that you know, it really did happen. And one of the persons who actually slept in the jail cell was my father.
Over who?
So what happened? Because we got arrested, we went to court. I had my information, as much as I had, defined to me, and I headed to court. What was a miracle was, if you see on this document, it says there was an ex parte motion to dismiss without prejudice. So unbeknownst to us, the prosecutor went and dismissed the case without prejudice because she wanted to bring it back later. So the case was done. I didn't know that. And I showed up for my court case, and Keakua and the Kupuna were both on our side, and our name was still on the docket. We had our day in court, and I raised the question about the political question, and that there is no authority here or jurisdiction, and that, you know, we had every right to be there. And the prosecutor did not have additional evidence to convince the judge otherwise. And because of that, he asked me what did I want. I said, this needs to be dismissed with prejudice. It needs to go away completely. And so he responded by saying, okay, I will accept your oral motion for reconsideration. I wasn't that learned in court proceedings, so I didn't know what he was talking about. Now I do. He said that I just made an oral motion and for reconsideration on the first dismissal without prejudice, and that I wanted it to be with prejudice, and it was granted. So it was dismissed with prejudice. Not 1, not 2, not 3, but all 16. There was a particular letter that was requested by the prosecutor, and she had asked that, because we were making all of these statements that, you know, we're sovereign, we're from the Hawaiian Kingdom, and she said, well, Your Honor, if they can prove from the United States and the state of Hawaii that there is a separation, then you can entertain their argument. And so I had a letter, because when I learned about this political question, I said, oh, so I'm not supposed to be in court. So I wrote to Senator Inouye. He was a congressman that represented the state of Hawaii. And he wrote back to me and he said he couldn't, but that he was grateful that I communicated with him. He had done some other correspondence to the police department to ask them what's going on in Hawaii. And I have those letters, but his particular letters clearly stated that there was a separation throughout the Constitution. And so that's what I used. And because of that letter, not just myself, but all 16 were dismissed with prejudice. So I will continue to also be defiant and stand up for our rights, only because I know that we have rights because of my identity to our country, and that we have a relationship with this foreign country, America, United States, but that it cannot and should never infringe upon my rights. And so because of that, I will make sure to go home to Nahiko, Ko'olau, to Kopiko'ula, where our ohana is from, and live again. Mahalo.